Ladies and gentlemen, ladies, ladies and gents, I am going to be doing an affidavit for someone. We're going to be putting it in court because this is one of those cases where the judge just denied everything. Now, before I got involved in this person's case, and this was November 2016 is when I first got involved in this particular matter, they had already gone on the internet, got in touch with some guy, put some junk, gotta say the truth, put some junk on the record, talking about all this other junk that had nothing to do with the case. The guy, he literally made it seem like he knew what he was doing. Put together a motion to look like a motion. Made it look like what the attorneys do because he thought he knew what he was doing. Well, needless to say, that didn't go so well. So guess what? I came in and tried to clear up the record, but there was so much damage done, including the person they used. He actually used the seal of the court on one of his documents. Yes, used the court seal or a replica of the court seal on his document, and they actually tried that individual for sitting up there and using that information without permission of the court or leave of the court. You people are desperate, but I promise you, doing a motion is not that hard. You don't have to talk like the court. So, look, some of you are pretty good, but some of you are not so pretty good.
Oh, he's trying to be politically correct, Mama. He meant to say some of them don't know what they're doing and they shouldn't even be touching anything that may be perceived as dangerous. They should be in a padded room for the rest of their lives and should be surrounded by white. That's what he's trying to say, but he's just trying to be PC. I just wish people would just say things the way they are and not worry so much about being politically correct. What you mean how I know what politically correct mean? I just said PC. Private company. I wasn't talking about no private. Oh, okay. Yeah, politically correct. Yeah. From now on, I'll say it. Okay. Oh, go back and listen to him. All right.
Ladies and gentlemen, there are some of you who literally, you just don't have the experience. You don't have the experience in working with computers. You don't have the experience in working and amending things. And people like myself, we take that for granted. See, some things come easy for some of us than it does for others. And because we know what we know now, it wasn't easy to know what we know, we forget about all the struggles, all the trying times, all the stress, all the effort that we had to endure to get to this point. So I feel for you, Shaka Khan. Sorry, we have this little rule that every time we use Shaka Khan's I feel for you, we have to give her credit. Just like, our girl Whitney Houston, she did I'm every woman, Shaka Khan. Okay, so it's just a tradition, y'all. Got to give Shaka Khan her credit. Shaka Khan. All right, let's go. We're going to start it with this affidavit. I want y'all to pay attention. Again, the court was killing everything, but we decided, let's ask some federal questions. Okay, so we're going to ask some federal questions. That little red mark, I just realized what that red mark is. That's the word federal appearing twice. Let's take care of that. Let's talk.
An affidavit. I response. 1. On the issue of whether or not I or any other defendant wishes to submit to the court's jurisdiction, we hereby rebut any presumption of any claim of any party that has made it appear that one must submit to the court's jurisdiction. There is no constitutional requirement nor constitutional laws or constitutional standard for such an absurdity. 2. I must inform this body that we have challenged the court's jurisdiction, a jurisdiction which has never been made to appear on the record as required by statute, administrative procedure and law. 3. On the issue of jurisdiction, and our right to challenge the court's jurisdiction, We now put forth these federal question before this court. Do we not have the right to challenge the court's jurisdiction? And if we challenge the court's jurisdiction, does the court not have an obligation to prove the jurisdictional facts asserted on the record? And if the court lacks jurisdiction, does any order, ruling, direction, opinion, suggestion, mandate, consideration, recommendation have any force at law, in law, any validity? For the reason why we ask those federal questions is because the court operates outside the scope of the Constitution under acts of Congress associated with the March 9, 1933 Act, otherwise known as the Emergency Banking Economic Relief Act, which led to the May 12, 1933 Act, otherwise known as the Federal Emergency Economic Relief Act. And if this body is exercising jurisdiction associated with these acts, we hereby challenge the jurisdiction of the court in addition to the aforementioned, based on the unconstitutionality of each of the aforementioned referenced acts of Congress. This court is bound by and required to go in accordance with congressional intent, and congressional intent with reference to the above-mentioned emergency acts of Congress is that Congress acted without jurisdiction when enacting the aforementioned acts. 5 Senate Report 93-549, July 24, 1973. Since March 9, 1933, the United States has been in a state of declared national emergency. These hundreds of statutes delegate to the President extraordinary powers exercised by Congress, which affect the lives of American citizens in a host of all-encompassing matters. This vast range of powers taken together, confer enough authority to rule this country without reference to normal constitutional process. 6 Federal question and federal challenge. Did the Congress have the authority to delegate its congressional powers to the President of the United States or any other branch of government? Could Congress delegate and/or confer authority to rule as sovereign representing the legislative branch of government to the administrative or executive branch of government? When Congress admitted in 1973 that they had indeed as a body, as a group, as a representative branch of government acted unconstitutionally, did such acts and/or acts invalidate the subsequent acts created as a result of the original unconstitutional act? Keep in mind the forbidden fruit, the poisonous fruit theory. 7 Then we have the issue of this court presuming that it could deny, strike, forbade, censor a party in their free exercise of a constitutional right. This body is well aware of the maximum that it cannot convert a right to a privilege. When the court ordered a party not to file another document on the record, despite the fact it allows the opposing party to file documents on the record, did it not violate the former's right to access the court? Their right to due process? Their right to equal protection of law? Please keep in mind the court never stated a single level of abuse, never responded to a single one of the presentments placed on the record, never responded to a single challenge placed on the record, and by not doing so that the court not abuse its discretion? 8 Because the Constitution has not been suspended, keep in mind it doesn't matter whether or not Congress introduced an article after the Bill of Rights was completed, that spoke as to the suspension of habeas corpus, equating that to mean that the Constitution may be suspended since habeas corpus being a constitutional right could be suspended. There was no authority within the Constitution to suspend the entire Constitution as a whole. There is nothing implied, and/or stated to come to such a conclusion, as the court is bound to go according to the original intent of Congress and the original interpretation of statute. The federal question is, can this court deny a party a right that is secured by the Constitution? 9 And if the court could deny a party a right that is secured by the Constitution, does that not invalidate all of the other court recognition that the court, or judge, or administrative agency, and/or party cannot deny or convert a right to a privilege? 10 This court allowed a magistrate to make a recommendation, when specifically, we said we did not consent to a magistrate, either we consented to a magistrate or we did not. In this case the court has denied us the right not to have our matter heard before a magistrate. When we notified the court that we did not consent to having a matter heard before magistrate, why did the court ignore our right and permit a magistrate to entertain our presentment? 11 We do not care that there is some rule, we care only that we had the right to deny a magistrate hearing our matter. We simply made it clear that we did not consent to a magistrate. That was a general refusal to be before a magistrate. 12 Once again the court is a private corporation, is it not? Owned by private owners, engaged in commercial business activities continuously, actively, even trading on the stock market. Is this in any way correct? If so, is this not a violation of the Clearfield Doctrine? We must keep in mind that the maximum which says that any time a sovereign entity engages in commercial business activities.
Okay, first we got to get rid of maximum and make it maxim. Speech recognition. Ladies and gentlemen, so that those of you who know anything about anything, so that you understand what was happening, what was occurring, what was taking place, is that this court, because of the junk that was placed on the record, told the petitioners they couldn't file anything else on the record. Now remember, they're not the ones who filed the original junk, but they authorized it because they allowed that they allowed that person who filed the information on the record to file on their behalf, who ended up charging them for his services and wasn't competent enough to do what he claimed he was doing for them. Added in literally sovereign citizen stuff. So they labeled these individuals as sovereign citizens. A terrorist. Terrorist. So basically what I said, wait a minute, hold up. You're going to block them from filing things into the record? And you're going to allow the opposing party to file things into the record? Sorry, that's a denial of their due process rights. If you don't want them to file something, just keep denying it like you were denying it before. But no, you can't stop them from filing anything into the record because there is no law permitting you to do so. See, the law says that they have the right to petition the government for redress. The right to petition is absolute. There can be no law or no limitations on that right. The court doesn't have a right to deny someone the right to place something on the record, is what I'm saying. Now, they understand the logic in that, they understand the reasoning in that, and they will sit up there and basically kill it. Okay? So, want y'all to hold on while I let the rest of it play. Let the music play. It won't get away.
They abandoned their sovereign capacity, and as evidence of that abandonment they waive any rights of immunity, electing to be sued and treated like any other ordinary corporation. Is this not so? 13. Does the court not require consent in order to exercise jurisdiction over a party? 14. If the court does not require consent, then why is it required a party to appear? Now we must keep in mind that any time one is made to appear, it means that they are submitting to the jurisdiction of the venue. Attorneys must put in their notice of appearance. As officers of the court they must submit to the jurisdiction of the court. They are bound by that requirement, so it is a reasonable federal question before the court as to whether or not one can be made to submit to the court's jurisdiction when there is no constitutional requirement to do so, or is there a constitutional requirement to submit to the jurisdiction of the court. 15. Then we have the fact that an attorney, an individual who engages in the unauthorized practice of law, remember the Supreme Court has stated in Sims v. EEON'S and Schwer v. The Board of Examiners, that no state may license, and this would include granting authorization the practice of law, because the right to practice law is not a matter of the state's grace. So how is it that this court is doing and condoning the practice of which has been determined to be unlawful, and creating the a bar of the court, requiring all of the attorneys who appear before the court to be a member of the so-called court bar? Does this not create a conflict of interest with respect to the parties in the case, knowing that pro se litigant cannot be members of the bar of the court, without receiving authorization, grant of the court, the grace of the court, and or license to practice before the court? 16. This court has gone out of its way to act with prejudice towards the petitioners, and we object. We are entitled to a fair hearing, not one that is so biased that the court blocks our access to the court, denies us the right to put in a response, even threatening us if we even put in a notice of appeal. Does the court not realize that that is why we did not put forth a notice of appeal? The court barred us from filing another motion and then sanctioned us when we responded to the opposing party. When we notified the court that the rules require us to put a response, when the opposing party brings forth a motion, the court ignored us and sanctioned us, abusing its discretion, denying us access to the court. So our federal question is, does the court have the authority when acting as representatives of the judicial branch of government to deny any party their right to petition the court, a branch of government? Keep in mind, if there can be no law against a right to petition the government, how can the court bring forth an order prohibiting one from doing exactly which the law says the court cannot do? We don't need to ask whether or not the court abused its discretion, we just need to know where is the constitutional authority for doing so. 17. We do not want the administrative branch of government to feel left out. We ask the following federal question of the court in its administrative capacity: does the court have the authority when acting as representatives of the administrative judicial system, have the discretion, power, license, sanction to deny any party their right to petition the court, a branch of government? Keep in mind, if there can be no law against a right to petition the government, how can the court bring forth an order prohibiting one from doing exactly which the law says the court cannot do? We don't need to ask whether or not the court abused its discretion, we just need to know where is the constitutional authority for doing so. 18. We must challenge the court's jurisdiction continually, because we have the right to a hearing before we are deprived of any significant due process rights. However, to request such a hearing we would have to submit to the court's jurisdiction. We would be granting the court license to ignore our challenge by demanding a hearing before body that lacks the constitutional authority in which the act. We cannot present anything to the court until the court acknowledges our right to know whether or not the court is acting in a judicial capacity or an administrative capacity. So the federal question is with respects this matter, is this matter in a judicial forum as representatives of the judicial branch of government, or is it an administrative venue acting in an administrative capacity? 19 Is legal terminology considered English? And when we speak of English, we are speaking of the common language of the people. It has been said that ignorance of the law is no excuse. However, the use of legal terminology, that is legalese, puts the common person at a disadvantage, denies them due process of law, in that legal terminology is a foreign language to the people. It is a denial of access to justice, to equal protection of law, to access the court, to access equity, to access the government. 20 Attorneys and judges go to school to learn this language that common people have no such training. There is no law, or constitutional provision of law which requires one to know legal terminology. Even if the Constitution is written in some aspects in legal terminology, there is no requirement of the people to know that terminology. Some people would say yes, there is, that everyone is required to know the law, that ignorance of the law is no excuse. However, if that were the case, then Congress, when they enacted the Judiciary Act of 1789 September 24, they would never have placed in there a provision which made it clear that every affidavit, petition, motion, writ, etc. was to be as any reasonable man or woman would understand. And we just made it quite clear that the common person, the common man, the common woman who by law must be reasonable, because that was the implications of the Judiciary Act when it spoke of understanding, do not understand legalese, that is legal terminology. 21 To speak even further on this point, if it was common knowledge for everyone to understand legal terminology, that is legalese, then attorneys would not have to go to school for 8 to 10 years to learn this foreign language. There would not be a separate dictionary for legalese, that is legal terminology, otherwise known as the legal dictionary and the English dictionary. 22 It is a denial of due process and equal protection of law to have two different languages spoken in the courtroom without a translator. The court was told that the plaintiffs did not speak legal terminology, and the court failed to provide a translator in violation of their due process rights and the general rules for the court. 23 Because the court operates in different capacities, we must ask the following federal question: is the United States Federal District Court for the Southern District of New York an Article III court? And the Article III court that we are referring to is the one authorized by the Judiciary Act of September 24, 1789, and the third article to the Constitution of the United States of America. 24 If it is, and we are saying it is not because the evidence proves it is not, but if it is, then why does your comprehensive annual financial reports, when considered along with the references, the notes, the ledgers, and the term definitions, identify it as a private corporation? Operating for private interest? 25 Now we know that all government as corporations, their body politics, body corporate. However, there is nothing granting a government in the United States of America to be private. Government may not be privately owned in United States of America. This is a fact. So then the federal question again is, why do your financial records as a venue show that you engage in commercial business and are a privately held, privately owned corporation? 26 If you receive an annual budget from the taxes that are paid by the people, which include forms, staples, office supplies, desks, salaries, operational expenses, then why do you charge additional fees to the public who have already paid their fees when they pay taxes? Is this not double taxation resulting in double jeopardy, a violation of their constitutional rights? If it is not, explain how not with the use of the Constitution and not some judge's opinion. You see, the judiciary was never given authority to make law, so case law is a misnomer. It is a violation of the Constitution, because the constitutional provisions only permit Congress to make law, not the courts. So constitutionally speaking, there is no such thing as case law, because case law amounts to unconstitutional law. So we will need responses to our federal questions based on the Constitution and not based on opinion and / or someone coming to a decision. We must insist on facts of constitutional law and conclusions of constitutional law.
Ladies and gentlemen, the reason why we know for a fact that the Constitution only permits Congress to make law, pay attention. First Amendment. Congress shall make no law. So the implications was already etched in stone, so to speak, when the First Amendment says Congress shall make no law. That documented the fact that Congress were the ones delegated to make law. Okay? That's why we know only Congress gets to make law. The executive branch doesn't get to make law. That's why they get to make and issue orders, orders. The same as the court issues orders. They're administrative. Okay, the courts were never given permission to issue an order. The courts were set up to handle disputes between parties. They were never supposed to be the judge and jury over a matter. Okay, you just got to understand the original reason for it being set up. The whole unanimous states thing.
Let's go back to our weeding, okay? Hey, David, you ready? Y'all, this is David. David. David says he's ready.
2. Administrative complaint. 27. Because this is an administrative agency, it must recognize the Administrative Procedures Act and the McDade Act. As such, we have
Look
the right
up
to
the
file this our
McDade Act,
administrative
people,
complaint
so
and
you
we include the
understand.
aforementioned information as part of our complaint. 28. We have experienced the clerk of the court blocking our access to the court, refusing to issue subpoenas, which as a party to the matter we had a right to subpoenas, and the clerk of the court refused to issue the subpoenas, denying us our due process right to access the court, to call witnesses, and to defend ourselves. 29. We also experienced judicial officers blocking our access to the court, denying us the right to petition the court, denying us the right to have our federal questions answered before the court, when we had this right. 30. The court making a determination for property held outside of its jurisdiction, the court acting without jurisdiction. The court recognizing that as a body, as a venue, the court. Please understand, when we use the phrase the court, we are talking about the institution, we're not talking about a building. The court is a legal term, not two separate words. The court could not exercise jurisdiction outside of its jurisdictional boundary, which is the District of Minnesota. So when the court actually made rulings concerning property and/or parties who are outside of its jurisdiction, it acted without discretion, and there is no gobbledygook this body can put together to explain away facts when dealing with the Constitution.
What's happening is my Word document has repopulated and populated and populated, but hasn't finished. I have to wait. Y'all don't mind. Because if I gotta wait, y'all gotta wait. See, now it's finished. Now we can go on.
31. We may
31.
continue to challenge to the court's jurisdiction, and because the court is an administrative venue, an administrative body, it must recognize that a challenge to us jurisdiction was a petition for redress equating to correcting a wrong, and the court, by refusing to deal with the issue of proving jurisdiction and all of the facts concerning jurisdiction on the record, left the court in want of jurisdiction and violating the Administrative Procedures Act codified as Article 5 of the United States Code. 32. So we bring forth this our administrative complaint within the body of this presentment to be placed before the executive officer of this venue to have our administrative issues and our federal questions heard, because we have this as a right. 3. Refusal to submit. 33. So once again we bring to this body's attention that we have a right to a hearing, but not just any hearing. We have a right to a hearing before a body and/or venue having jurisdiction. We demand our hearing, but only before a venue having jurisdiction as delegated by the Constitution and Article 3 of the Constitution of the United States of America. Is it not ours as a right to be before a constitutional court? 34. Because we've asked to be before an Article 3 constitutional court and judge, we demand the free exercise of this right, and we at this point at this time present to and before this body our motion, petition, presentment to have this matter dismissed, via demurrer. 35. We already provided proof that the United States is still experiencing a national emergency extending the March 9, 1933 Act of Congress known as the Emergency Economic Bankruptcy Act. 36. Now before you say that that's a bunch of gobbledygook, yes, gobbledygook is one of your words, your legal terminologies, let me give you Congress's own words. We are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the United States government. Congressional Record March 17, 1993. P.H. 1303. 37. You will say that's not true. The United States is not bankrupt. The United States is not in bankruptcy. However, Congress has admitted this, and when it was stated on the congressional floor no one rebutted it. 38. Plus, we have the fact that the United States Treasury, and we must consider the Treasury because under the Act of March 9, 1933 they have been delegated authority and power respecting the regulation of the currency, has admitted that legal tender in the United States has no value. So how in the world could this court issue a judgment against someone when we are in bankruptcy as a nation, when legal tender, Federal Reserve notes, properties, have no value? Federal Reserve notes are not redeemable and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves. https://www.treasury.gov/resource-center/faqs/currency/pages/legal-tender.aspx, an official website of the United States government. 39. Although the United States Treasury is responsible for issuing lawful money in the United States according to the aforementioned acts of Congress which we've already seen were/are unconstitutional, the Treasury does not have a provision for providing lawful money to the citizenry, the national community, the people. 40. We informed this court that it had no jurisdiction respecting our persons, that we are not United States citizens or persons as defined by the 14th Amendment Section 1, that we are not taxpayers, and yet this court has provided no proof on the record that it has jurisdiction over us which is required by law. We demand that such proof be made to appear on the record immediately, and that the court state precisely what the jurisdiction of the court is, with specificity. Is the court refusing to provide this information on the record? If it does refuse or fail to address that would mean / be prime facie evidence that the court did not have the jurisdiction for which it presumed it had initially, which would completely invalidate these proceedings from their inception. 41. So no, we do not consent to this court entering judgments against us, rulings against us, charges against us, motions against us. We do not consent to the court's jurisdiction. We have never consented to the court's jurisdiction. We will never consent to this court's jurisdiction. 42. We do not appreciate being coerced, nor do we appreciate any organization, private or otherwise, impersonating the United States of America government. Such is illegal and it tramples upon the sovereignty of the United States of America, and we object to such treasonous conduct. 43. So we challenge the court's jurisdiction and we challenge the Act of March 9, 1933 each as being unconstitutional, and we do so respectfully. The aforementioned we affirm is attested to as factual and is wholly accurate as presented on this April 17, 2018. So help us God.
Okay, ladies and gentlemen, and ladies and gents, so that it is clear what we're doing, let's minimize that and let's get rid of that. We're responding to the court, and because of the different things that's happened in this case, those points that were brought up because it's time to take off the gloves. We hadn't been going at them for the stupidity of which they call a court. They're administrative. There's nothing in law that allows that administrative venue to operate the way that administrative venue operates. It's all by consent. So now we challenge all the aspects for which allows that venue to operate, which is the March 9, 1933 Act. That's the first thing, because that's where they got their start. So that's the first thing, because it's the foundation of the court's jurisdiction, the administrative branch of government's jurisdiction. Why? Because when the administrative branch set up courts, it couldn't do so. You do know that the administrative branch and the congressional branch can't set up courts. Why? Because Article 3 only permits pay attention, wait for it, the judicial branch to set up courts. Don't believe me? Go back and look at Article 3. Okay, and the Judiciary Act of September 24th, 1789. So why do they get to have administrative law judges? Because administrative law judges work for the administrative branch. So why do they get to have administrative law judges and have this facility called the court? Because the court is an idea. It's not an actual place. I.e., that's why I had to explain when we say the court, we're talking about the institution. We're not talking about a building. That building that they have the word court on is not a court. That's why you're in contempt of court. Excuse me, how can you be in contempt of a building? No, what they're saying is you're in contempt of an institution that is constitutionally ordained. So I'm now challenging that on behalf of these individuals. Why? Because you can't do that. You can't manipulate the Constitution to say what you want it to say. Well, that's what you're doing when you write these motions for these people. Excuse me? You're sitting up here manipulating the Constitution to fit your whims. Good. I'm glad you got that, because if they can do it, we can do it. Equal protection of law. That means everybody has equal access to law. Then the thing about the legalese, about how it is a foreign language, about proving to them it's a foreign language, the first thing they're going to say, and I've not heard one judge say it to this day, but the first thing they will say is the Constitution was written in legalese. I guarantee you that's how they reasoned, but they don't get it. Just the fact that the Constitution was written in legalese doesn't mean that the people were required to know legalese. Legalese is not a language that the American people are required to know and abide by. Ladies and gentlemen, this information being presented to you. Take and pull out of it what you can use. That's why the video is being done. I promise you, if you're doing motions, there's something in this one that you should be able to acquire and use. Have a good day. Have a good life. 29 minutes and 30 seconds. Goodbye.